The Group of Companies Doctrine. Hello, this presentation is a brief introduction to the Group of Companies Doctrine to support some courses which I'm running on international arbitration. The point of the presentation is to brief participants on courses which they're about to take part in, and it's definitely not an exhaustive or scholarly treatment of the subject. It's generally true to say, under the laws of most countries, that a non-party to a contract is not bound by its terms, and neither can he or she enforce rights under the contract. But there are numerous exceptions to this principle under the laws of most countries. For instance, principles of fraud, lack of good faith, and estoppel will, on certain facts at any rate, provide a way around such general principles. In the case of companies, it's possible under the laws of some countries to pierce a corporate veil, or to treat a person who is the alter ego of a company as if he were the company. The Group of Companies Doctrine is in this tradition of exceptions to the general principle, but as it's normally understood, it applies only in the specialised case of arbitration agreements. That is, where the doctrine applies, Company A within a group of companies will be bound by an arbitration agreement, will take the benefit of an arbitration agreement, will be bound by any resulting award, or, as the case may be able to enforce any resulting award, even though a different company within the same group was the party to the original arbitration agreement and not Company A. Now, an arbitral tribunal always has to take a view on its own jurisdiction. Not only must it be satisfied that it has jurisdiction over the subject matter of the dispute, but, and this is the relevant point here, it must be satisfied that it has jurisdiction over any person or company which it's suggested is a party to the arbitration agreement. Now, although arbitration agreements often appear as a clause within a wider commercial contract, it's an invariable principle in international arbitration that the arbitration agreement is autonomous. That is, not only can the arbitration agreement survive an invalidating attack on the parent contract, but also the validity, scope, and effect of the arbitration agreement can be subject to a law other than that which governs the parent contract. But it's remarkably rare for an arbitration clause within a contract to include its own specific choice of law agreement. Should a question about the law which governs the arbitration agreement come before a national court, the court will apply the conflict of laws rules which apply in the forum to determine which law governs the arbitration agreement. Now, although within the European community the Rome Convention normally supplies these conflict of laws rules, that convention expressly does not apply to arbitration agreements. And when it comes into force on the 17th of December 2009, the Rome I regulation will take the same approach. It follows that judges sitting in national courts within the European community have to apply their own national conflict of laws rules to this question. But the important point for current purposes is that an arbitral tribunal has no set of conflict of laws rules to apply. Certainly, the fact that the seat of the arbitration is, say, England, doesn't import the English conflict of laws rules. So the question is, what set of norms should and does an international arbitral tribunal apply to questions over the scope and parties to the arbitration agreement that founds its own jurisdiction? Well, in practice, one would expect a tribunal to respect an express choice of law in the rare case where there is such a thing. If the arbitration agreement incorporates a set of institutional or other arbitration rules, these might provide a complete, or much more usually a partial answer to the approach to be taken by the tribunal. But outside these cases, one would expect the tribunal to identify the intention of the parties. Now, the Group of Companies Doctrine springs out of this intention-determining process. The interim award in this case was reported in the Yearbook of Commercial Arbitration for 1984. The parent company was Dow Chemical Company, a US company. It was the parent company of Dow Chemical AG, which was a Swiss company. That company in turn was the owner of Dow Chemical Europe and Dow Chemical Europe granted distribution rights to a number of French companies, which later assigned their rights under the distribution agreement to Isova Saint-Gobain. Under the distribution agreements, Dow Chemical Europe was able to deliver through a number of companies, any subsidiary company of Dow Chemical Company, and also, in particular, Dow Chemical France. In the eventual arbitration, Dow Chemical AG and Dow Chemical France were parties to the arbitration. In the Dow Chemical case, a dispute arose between the parties to the distribution agreements. Those distribution agreements contained ICC arbitration clauses. 4 Dow Chemical companies commenced an arbitration, 2 of them being parties to the distribution agreements, and 2, Dow Chemical France and Dow Chemical Company, not being expressed to be parties and not having signed the distribution agreements. In an interim award, the tribunal had to decide whether these 2 non-signatory companies were entitled to the benefit of the arbitration clauses in order to take part in the arbitration. The tribunal decided that they were. It decided that in the absence of any expressed choice of law to govern the arbitration agreement, the parties' choice of ICC arbitration, and therefore their selection of the ICC rules, represented a choice that the tribunal should decide its own jurisdiction without reference to any national law. The tribunal therefore decided that it should determine the matter by reference to its view of the parties' intentions at the time the distribution agreements were entered into. And deciding this question of intention, the tribunal particularly had regard to 3 factors. First, that Dow Chemical Company exercised absolute control over its subsidiaries. Second, that the Dow Group constituted one single economic reality. And third, that the parties' intention that the signatory companies should bind others in the group was apparent from the fact that the contract provided for performance by Dow companies which were not signatories. In the tribunal's view, previous ICC awards had established a case law which subsequent tribunals should take into account in the application of the group of companies doctrine in order to decide the intention of the parties. Now, Isova Saint-Gobain applied to the Paris Court of Appeal to have the interim award cancelled. This application was rejected on the ground that the tribunal was within its rights to have made the ruling. Now, in a much later case before the English Commercial Court, Peterson Farms against C&M Farming, Mr. Justice Langley was asked to rule that a later ICC arbitration award was made without jurisdiction. In that award, the tribunal had applied the group of companies doctrine in an arbitration between an Indian claimant and an American respondent. Part of the damages claim brought by the claimant was for losses suffered by other entities within the claimant's group. The parent commercial contract was governed by the law of Arkansas, and Mr. Justice Langley held that the question whether the affiliated entities were parties to the parent contract was therefore a question of the law of Arkansas, and under that law they were not parties. Well, that was enough to decide the question against the claimant companies, but for good measure, Mr. Justice Langley went on to hold that the law of Arkansas also governed the arbitration agreement, and in so doing he appears to have applied English conflict of laws rules. Well, certainly it's appropriate that an English judge should apply English conflict of laws rules, but it's unclear why he thought an international tribunal should do so. That concludes this presentation on the group of companies doctrine.